Okay, my name is Isaac Christopher Luvogo. I pride myself in being a legal jurist, an academician of sorts, and a writer of law books, probably maybe the most celebrated writer of about 34 books now running, legal books, and particularly in the areas of the law. Um, I would love to have a discussion in terms of anti-homosexuality debate right now that is happening in the country. I know I was one of those guys who went to parliament to make deliberations in respect to uh, why Uganda should or should not have a law in as far as homosexuality is concerned. So I am a little bit conversant with some of the issues that may become dicey at a certain time. Particularly, I would like to address my mind to a book that I wrote called The Strict Mythology, Demystified, produced by Jesco Publishers in 2023. But this book basically discusses everything that has to do with homosexuality, but more importantly, LGBTQ. And by the way, there's a difference between homosexuality and LGBTQ. And that's what another misnomer that we have even as we begin arguing the prominence of the bill. So I am aware that this bill came back to Parliament by virtue of my friend and OB, the Honorable Basa Aliwa, but it had initially been brought by the Honorable Bahati and thrown out on a technicality at the Constitutional Court because at that point Parliament did not have quorum to pass the law. So the question of whether or not this bill will survive is a question of debate. There's no doubt in my simple analysis or even interaction with the people, the majority of Ugandans, that the overwhelming number of people, by virtue of ideology, believe that perhaps homosexuality is a foreign thing and therefore shouldn't be part and parcel of our laws or even our culture for that purpose. But I'm also mindful of the fact that jurisprudence has it that Africa had a number of instances where homosexuality was actually practiced. To give an example, Nziga, Queen of Congo, who actually, that is way back in 18 something, who basically practiced the aspect of homosexuality with her maids and stuff like that. And then there's also argument of Mwanga of Buganda, King of Buganda, who is allegedly also in fact was having practiced homosexuality. That's a question of another debate. I can diverge into that and argue it in terms of whether or not it was a smear campaign by the white man, because Mwanga was plus Kavariga was at the forefront of fighting against colonialism. So there's an argument that they were probably trying to mudsling and trying to, discourage him from his people, take him away from his people. And they rightly did so, as you remember, when he was actually incarcerated together with the Kavariga in an island, okay, Sicily's island or something of the sort. So for starters, we argue that previously this bill was introduced in 2009 and was passed by Parliament in 2013. It was assented to by the President in 2014 and then annulled by the Constitutional Court in 2014 on the grounds of lack of quorum. That's what I told you. So here comes the private member's bill, which was introduced by your friend and my OB, Vujirimi MP, the Honorable Asman Basaria, on 3rd March 2023. And amongst other things that were included in the bill were issues to do with sexual relationships between persons of the same sex and the promotion of such acts. So also the bill basically sought to amend or to fill the gaps that had to do with what the penal code was not able to argue. I mean, someone can ask what specifically was in the penal code, but we all know Section 145 had to do with, curbing down offenses or acts or omissions that had to do with unnatural acts, as it were. So, while considering the bill, legislators had to agree on a number of things, and I'm talking about the bill that was sent back. Remember, the bill was passed with a vote of 354. About 3 people didn't vote. Of course, one voted against, Fox Odoi, and then it was sent to the president to assent, which is, the procedure of law. And the president, on recommendations of the Attorney General, who, by the way, was part of the member, even at the passing of the bill, writes what? Another, call it response, in a sense that he's not associating himself with the assenting of the bill. And his argument, without even it going public, had to do with a number of aspects that had to do with constitutional interpretation, and it came to the argument of homosexuality. You see, it is one thing to argue against homosexuality. It is another to prove the act of homosexuality. Those are two different things. And then one thing we must understand is that we as Africans, perhaps the biggest challenge we've had as Africans is the fact that we are thriving in a nation which, or quote unquote, grafted itself on foreign law by virtue of the Inception Clause and the Order in Council. And some of these things have now far-reaching consequences on us. So we begin asking ourselves, what is happening? Is it our law? When we make and argue entirely, look at chapter 4. Chapter 4 basically argues human rights. And you cannot divorce some of these things with aspects of human rights. If you're going to argue in terms of human rights, I think it was Professor Sylvia Tamale who was arguing, said, if you're going to accept certain aspects under the premises of human rights, then you're not going to let some off and then let others on. In other words, you cannot have your cake at the same time give it away. Perhaps I'd like to agree with her on that concept. Perhaps my only disagreement with her is in respect to arguing that homosexuality is what? An offshoot of Ubuntu, in her argument that she made before Parliament. I would like to argue otherwise when it comes to that. But what are the contentious issues that perhaps are evident enough in this bill? Well, number one, the bill proposes a sentence in prison for an individual convicted of committing the act of homosexuality, whereas an attempt to perform such would attract even a 7-year term period. So we're talking about the principle of what? Of legality, the term. And then the bill provides for a 3-year imprisonment for a child convicted of an act of homosexuality within the line of Section 94(1) of the Children Act and Cap 120. And then also the bill proposes death penalty for anyone engaging in aggravated homosexuality. And that becomes a tricky one because we all know that Uganda practices or enjoys or carries out death penalty, even by virtue of Susan Chigula. Although there was a revisitation of that particular case in terms of the constitutional petition of Susan Chigula, where they argued that Susan Chigula, the fundamental aspects, by the way, was part of that debate because I was working for Katende Sempeva, so I actually went and argued on that in the Supreme Court on that matter. So the issue was they removed the mandatory aspect of shall suffer death to may suffer death. So they made it discretional for judicial officers to engage that. So we know that death penalty is an issue. And now we are still, in light of changing jurisprudence, we are realizing that death penalty is becoming a non-issue. I mean, let's give an example. Ever since that case, how many people have actually been put on death row? And now there's even an aspect of remission. If someone has been on death row for a number of years, then automatically they will remit them to life imprisonment. So I think the president and the powers that be are reluctant to enforce the issue of death penalty. So now if you reimpose death penalty, in respects that have to do with aggravated homosexuality, then someone will ask and say, are you really serious? So that's food for thought. Then the provisions also embedded in the bill seek to protect the traditional family by prohibiting any form of sexual relationship between the persons of the same sex and anyone who is actually promoting such an act. That is not debatable. We all agree with that. The bill also seeks to address gaps in other laws, including the Penal Code Act, Cap 120, as well as supplement provisions of the Constitution by criminalizing what they call same-sex acts. So while considering the bill, the legislators also agreed to a penalty of about 1 billion shilling. Think about that, imposed on a legal entity convicted of promoting homosexuality. That becomes a question of debate again. Now we are seeing, listen, first of all, for starters, we understand that the right for, call it homosexuality or LGBT is protected under, and I'm using the word protected in quotes, under the provisions of Article 43, which had to do with an aspect of a right to what they call derogable rights, freedom of expression, freedom of speech as provided for under Article 44. Now, when you look at Article 42, when you look at Article 43, 43 actually sets the limitations, and then 44 creates grounds for what they call non-derogable rights. Now, one of the non-derogable rights, which is a fundamental right, which is non-derogable, the Americans have this other argument that we hold this truth to be self-evident, that all men are created equal, given certain inalienable rights. So Article 44 creates what they call non-derogable rights. So a right to fair hearing is a non-derogable right. Now you are using a derogable right against a non-derogable right. You see, so that's another defeat of sorts legally. So the legal interpreters are going to say, what are you talking about? Now, I'm not yet going to the nitty-gritties. I'm just simply pointing out the aspects of the bill that have issues constitutionally. The bill provides for 3-year imprisonment of a child convicted of an act of homosexuality in line with 94, Section 94, subsection 1G of the Children Act. I just made a point in respect to the culpability that has to do with the legal officers or any other person protecting the interests of those people. I've not even talked about the fact that the bill, in essence, actually lacks even renovations or rehabilitation centers. And I'm going to make reference to that because His Excellency made specific provisions when he sent back that bill, and those were the issues that he wanted to be revisited. So it is argued that Uganda is obviously a signatory to a number of international agreements that actually interpret to recognize what they call sexual minorities, and that's where the challenge is. And such agreements, although they do not legally bind, they are actually persuasive. And that persuasivity is actually linked to a monetary string, if you like. And that monetary string supports 3/4 of your economy. Think about that. Uganda's GDP as of 2022 was about $851 per capita. Think about that. Reduce that in terms of year, that's about what? That's about 3.27. Reduce that in terms of month, that's about 270,000. So on average, an individual who is a public servant is ordinarily required to receive about 270,000. So how many of you and I can survive on an average of 270,000? Think about that. That's another lacuna that we have. So you know that you're actually thriving with an issue that, quote unquote, actually helps to propagate or even sustain your government. The gross national income of Uganda generally is about 851. Think about that. So again, those are questions that have issues to do with debate. And I've not yet got into the depth of it. But let me just continue. When you argue in terms of the proposition of the bill, as I said, Honorable Fox Odoi, who was the only person who presented the minority report, was saying that the bill is misconceived and did not have what they call comprehensive provisions in catering for anti-homosexuality. And he said that the bill was a duplication of other provisions in terms of existing law. I met Honorable Fox Odoi when I was arguing before Parliament. I'm disappointed that he argued that shallow, to use that phrase loosely. I would think there were better propositions to argue when it comes to that, but anyway, we will get there. So it's therefore the position of minority that the provision of the bill, if passed, will infringe on the rights of Ugandans, expression, freedom of expression, association, and liberty. That's what your friend Odoi is saying. I think I would invite Odoi to look at Nabagesera judgment and the justice and the judgment of Justice Musota, which is settled law. And I made this proposition before him, by the way. And I'm just surprised that he wasn't able to pick it up. Now, Vox Populi, Vox Dei, which ordinarily is a Latin phrase that means that the voice of the people is the voice of God. The phrase basically suggests that the opinion of the majority should actually be considered as the will of God or of a divine, voice. It implies that the popular, or popular majority opinion in terms is the right one, because that is representative and respected as far as what people would desire. And that's probably in consonant with the passing of this law substantively, if you like, in terms of judicial jurisprudence, if you like. Then perhaps if you were to argue in terms of solus populi suprema lex esto, which means that the welfare of the people is supreme, then that phrase can also be argued in terms of the safety of the people, and that should be the highest priority in terms of interpretation of some of these concepts. And that's where I'm coming to. And perhaps the better person in terms of arguing that principle is your friend, the Speaker of Parliament, who said we will do laws that govern and represent the norms and customs of our people. That's her argument. Let's go back to the bill. The bill provides for penalties that prohibit acts and expose children to acts of homosexuality by imposing a 10-year prison sentence on a person found to recruit or even for purpose of engaging in terms of these acts. The bill also seeks to penalize an owner or an occupier of a premise or premises who knowingly gives remedy or accepts people to engage in acts of what, to a tune of 10-year imprisonment. That's understandable. Then a person who contracts a marriage with a person of the same sex, presides over the same-sex marriage, knowingly participates in such blah, 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 he's also liable to a conviction of what? 10 years. I may not have much struggle with that because that's a little bit. So, the question is, the bill also criminalizes those who promote homosexuality or attempt to commit the act of homosexuality, as we have already argued. But there is an interesting argument that was proponent by His Excellency, and that is probably what I wanted to come to very, very, very soon. But perhaps before I go there, I would like to point out that the bill raises questions of whether or not criminalization of these sexual acts can also be argued in terms of sexual orientation or gender identity. Now, that's where the problem is, because you see, you must understand the difference between sex, sexual orientation, and gender. If you fail to understand that, you're in serious trouble. And the bill does not categorically bring a distinction in terms of that. And I'm going to argue and explain why. The bill basically resolves to protecting people of LGBTQ, by virtue of the African Commission of Human Rights. And that's right, because the African Charter, 9, I think, Article 9, Sub-Article 2, makes the proposition that countries are encouraged to form laws that, thrive or drive or protect the interests of their own cultures, as it were. But it still says that this should be done in consonant with what? With other international obligations. And that's where the problem is, you see. So we know that for a fact that about 30 countries in Africa have this law of banning same-sex conduct, and therefore outlawing. The only problem with the one of Uganda is that it's a little bit more, to use the word loosely, callous, or perhaps extreme in the sense that it imposes death penalties as opposed to other lighter punishments, if you like. And I'm not saying it's bad, but I'll explain some of the challenges that have to do with that. Now, if we are to continue in still that respect of argument, then we can argue as well that your friend, His Excellency, on 21st March, passed the anti-homosexuality, that's 2023, Parliament passed the anti-homosexuality bill, and we argued that 387 out of 389 voted in favor, so the bill passed into law, but the President must assent, not so. And on 2nd May, which was when? Yesterday, Parliament voted for the second time to pass the bill and resend it to His Excellency for purposes of being what? Assenting. So this means that the President has certain options to either pass the bill into law or send it back to Parliament, which means Parliament, on the basis of what they call parliamentary supremacy, has a right to pass it into law and with or without sending it back to the President, in the event that the President refuses to sign the second time. So issues that have to do with parliamentary supremacy and the power of the President in terms of assenting to it are provided for in the Constitution. You look at Article 91, Sub-Article 3. I'll not go there, but also look at Article 91, Sub-Article 4, which provides for, where instances where the bill will be turned back to the President. And this has happened before, during the time of Dr. Milton Obote, where a bill was sent. If you remember the referendum that to do with the Buyaga versus Bugangaizi, remember that issue? When the President was, 1 year after independence, after the Marlborough and Lancaster conferences, they agreed that come independence, 1 year after, we shall vote whether or not Buyaga Bugangaizi will go back to where? The people of Bunyoro. What happened? It went back, and after the referendum, and President Mutesa at that point was at a crossroad in terms of reality. Was he a better Muganda or a better Ugandan? He chose to be a better Muganda and refused to assent. And what happened? It had, effects. His Excellency, Dr. Apollo Bode said, Shiragali Dembazi, Shiragali Sudde. So what does he do? He says, Parliament, make it good law. Parliament does that. And that was the beginning of the first Kabaka crisis, if you remember. And that caused a lot of problems. So, as I said, there are a number of strict provisions that had to do with that, especially in aspects to do with aggravated homosexuality, which I would understand, by the way, because they are saying that to include having gay sex with people having HIV. There's also aggravated rape, as you're aware. But questions of death penalty, as I said, are now losing touch in terms, although we know that even in America, there are still countries that still believe in that. So, and then the 20-year sentence of promoting homosexuality, where activists say that it could criminalize anything to do with advocacy of the rights of lesbians, bisexuals, transgenders, and queer citizens. Now, that's another issue that I would like to argue as well. So when you look at Article 79, it provides for, functional areas to make Parliament competent to make such laws, as I've already told you. I'll not go into the nitty-gritties of what is required for purposes of doing what? For purposes of passing the bill, how it is passed, what are the procedure guidelines, what are the rules. Those are issues that may not attract, substantive interest now. But the process of passing the rules are provided for in the rules of procedure of Parliament, especially Rule 23, Sub Rule 1. When you look at that, and then Rule 2, it has all those elements. Now, what is worth noting is that after the return of the bill, the House with proposals for reconsideration, this bill that criminalizes acts and promotions in terms of homosexuality was passed on 22nd March, as I'm talking about. So the President is likely to assent. However, some of the issues that the President pointed out was saying it is important to distinguish between a homosexual and engaging in acts of homosexuality. That is one of the things why he refused to assent the first time. So he said, by the way, this bill does not make a distinction between being homosexual and engaging in acts of homosexuality. I'm not sure whether the President is sure of what he's saying by saying that. I take that with a pinch of salt. And therefore, his proposition that the bill should be clear and should be sought in terms of criminalizing and not simply having what they call a deviant proclivity. And that's another interesting animal, a deviant proclivity. But rather actions of one that are deviant, that are not deviant in terms of promoting. Now, what do we mean by having what they call a deviant proclivity? And that's the interesting argument here. If you're arguing that, then you must understand that having a deviant proclivity refers to having a tendency or an inclination towards the behavior that is considered abnormal, unusual, or outside the societal norms. And this can have a range of behaviors, from criminal activities to unconventional sexual desires or preferences. So it is important to know that not all deviant behavior is harmful or illegal. Okay, and the individuals with such proclivities may not necessarily act on them. Think about that. If you can accuse me for misprision of treason, then why are you saying you cannot accuse me because you're not sure whether I have this deviant proclivity? That's another question of debate, and I'm not sure how that's going to be sorted in terms of jurisprudence. So the President added that any person who is believed to be homosexual but does not engage in homosexuality or its promotion commits no offense, as stated under Article 2 or 3 of the bill. Okay? I think that's fair enough. So the President was concerned with Clause 14 and 15 of the bill when read together, and also to appear to create what they call unnecessary contradictions, which may cause a challenge in the implementation of the law. And these are the things we told Parliament when we were invited. Said, listen, take it one by one. Invite professionals, invite scholars, invite people who have actually had a debate in terms of the things. Clause 14, for example, imposes the duty of one to report suspected cases of homosexuality. And Clause 15 makes an offense for one who makes false allegations. Then issues of whistleblowers are also going to come into question. The fear of whether or not what I'm saying is right. How are you going to prove? I saw you in the window, but I cannot say it. Did I take pictures? Now there's even a law where you are, okay, it was repealed, the computer issues, but substantively there are those laws that had to do with taking pictures or taking recordings or videos and stuff like that. So that contradiction presents challenges in terms of the implementation of the law, and therefore could actually be a source of conflicts in society. So Clause 14, in his opinion, has to be reviewed with the aim of removing altogether or restricting it to apply for protection of children and vulnerable people. And then he said that his desire for in terms of rehabilitation of people formally engaged in the homosexual act is another question of debate. And perhaps what the President forgot here is what I learned from my friend, my brother Katende, who made this argument and said there must be a difference between conversion theory and affirming theory. And I'm not talking about Katende Sempe, I'm talking about another Katende, a brilliant young man who argues in terms of IT and things to do with artificial intelligence. So the conversion theory and affirming theory are two main approaches to understanding the treatment of LGBTQ individuals. Conversion theory is known as what they call reparative, or what they call ex-gay therapy, and is based on the belief that homosexuality is a mental disorder that can be cured or changed through a therapy or other interventions. And usually the proponents of this theory argue that individuals can actually overcome same-sex attraction by addressing underlying psychological or emotional issues, such as trauma. On the other hand, affirming theory is also known as acceptance or identity, and that's what's happening in America and the likes. They have dropped conversion. They're now talking about affirming. You only come. Think about this. Even a child below 16 years in the US, you cannot simply say, "Hey, by the way, I have a baby boy, a baby girl." You know, you can't call him a she or he. The discretion to call is dependent upon the child themselves. Although what is alarming is that the issues of voting is up to the age of 16. So you're asking yourself, wait a minute, where is the world going? A child cannot you cannot simply call your child a he or she. It has to be dependent upon that. That's interesting. And then you cannot begin aspect of conversion. You'd rather use affirm if they say, I have this tendency of, inclination towards my same-sex likes. Those are questions of debate. So, anyway, that's what your president said, and I cannot agree much. I will leave it at that. But I have my questions that have to do with the bill itself. When you look at the African Commission of Human and People's Rights, which adopted Resolution 275, it condemns attacks on the state and non-state actors against persons based on their sexual orientation and gender identity. And again, that's where the problem is. You see, if you look at the Kenyan case, Eric Gitari versus NGO board, that is where the what do you call it? The blue bullet, or whatever you want to call it, was actually, that's where the game changer, took place. In terms of interpreting sexual orientation, gender identity, and the general and purposive definition of the word sex, that must come in, regardless of whether or not you want to restrict yourself and say, for us as Ugandans, we understand sex according to height versus height as a sexual relationship between one man and one woman to the exclusion of others. Height versus height has been overtaken by events. So the interpretation of sex has taken another connotation. There has been a progression in that direction. Now, how are you going to argue in terms of internationalism? You are saying we want internationalism, human rights, but we are not willing to accept the other part of it. And please, for the record, please don't think I'm arguing for homosexuals. No. I'm just opening your minds. I'm just making you think outside the box and throw the box away. I'm here to make you think, like some friend, that England politician who says, I'm here to make you think.com. So, even on 20th April, after the issue of the homosexuality bill taking coincidence in Uganda, European Parliament passed a resolution on the universal decriminalization of homosexuality, considering recent developments in Uganda, which called on the president not to assent on the bill or any other similar legislation in future. Can you imagine? And now these guys give you lots of money. Now Parliament passed the bill, as we have argued, and it retained executions that have to do with sexual activity and introducing even harsher punishments in terms of certain categories. So the inclusion of death penalty, for example, would open the bill to a challenge in terms of the use of capital punishment. Okay, as the Deputy Attorney General Kafuzi Jackson wrote a letter to the President of the second, intimating and giving him that kind of advice. So we are aware that aspects of aggravated homosexuality are quite evident in the bill, and as I said, those are questions that are going to cause debate at a certain time. Now, what is also important to understand is that the bill basically lacks a general and purposive interpretation, as I said, of the word sex, sexual orientation, and gender. Now, if we are to interpret the word sex, sexual orientation, and gender, we can have various legal implications. But in general, what happens, courts and legal authorities have adopted a broad and purposive interpretation when it comes to interpretation of sex or definition of sex to ensure that they include and provide for adequate protection of individuals, including those who identify as what? LGBTQ+. So regarding the word sex, in many jurisdictions it has been interpreted to include both biological and gender identity. Think about that. For instance, in the US, under Title 7 of the Civil Rights Act of 1964, has been interpreted by the Supreme Court to prohibit discrimination based on both biological sex and gender identity. When you look at Ossock versus Clayton, which was a case of 2020, court held that the discrimination against an individual based on their sexual orientation or gender identity is necessarily a discrimination because of sex. Are we there? Now that's the problem I told you. You want to have your cake, but at the same time eat it. Similarly, when you look at sexual orientation, it has been broadly interpreted to include all forms of attraction, not limited to just heterosexual or even homosexual orientation. For instance, the Human Court of Human Rights has held that sexual orientation is a broad term that includes what they call sexual attraction to persons of the same sex, opposite sex, or both, as well as other characteristics related to sexuality. And lastly, the term gender has also been interpreted to include both biological and gender identity. By the way, we're talking about 70 genders as we speak today. In Canada, for example, the Supreme Court has held that gender identity is protected on the ground under human rights legislation, and that discrimination based on gender identity is a form of sexual discrimination. In other jurisdictions such as Australia and UK, gender has also been interpreted to include gender identity. So you see where the problem is. We're opening up a can of worms. So in conclusion, in terms of interpretation of the word sex, sexual orientation, and gender, it has acquired what they call a broad and purposive in many interpretations. Some of you who know what sexual interpretation means, you know that we always give a general and purposive interpretation. Okay? And I have just discussed particular issues that had to do with that. Now, when you look at the African interpretation of the word sex, sexual orientation, and gender in Africa is a complex issue. It varies depending on what they call jurisdiction and in terms of specific legal context. However, I will note and argue in terms of, for example, provisions of the African Charter on Human Rights and People's Rights, which guarantees the right to equality, non-discrimination on various grounds, including sex and other status. You see how you're getting yourself in a problem? Even when you rely on African Charter, we are still saying if you're defining sex, you should include it in terms of sex and other status. So the African Commission on Human Rights and People's Rights, which is broadly responsible for applying those provisions, has held that other statuses include sexual orientation and gender identity. It is in resolution protect against sexual violence or violence of other human rights, as it were. Now, when you look at the Commission, it stated that discrimination based on sexual orientation and gender identity is a violation of the right to equality and non-discrimination. There you are, my friends. Even when you look at the case of National Coalition of Gay and Lesbian Equality and another versus Minister of Justice, which is 1998 in South Africa. This case, the Constitutional Court of South Africa held that discrimination on the basis of sexual orientation is a violation to the equality, human dignity, and freedom of other discrimination. And the court held that the term sex in South African Constitution should be interpreted to include gender identity, which means that discrimination against transgender individuals is also what? Prohibited. You see? I told you that. I told you that. I told you that. You didn't listen to me. I told you that in Parliament. Now, however, and I'm not saying that these are persuasive, rather what, or binding precedents. They are persuasive, yes. But if you are relying on African Charter, which is actually saying that, how are you going to escape that? I will give you escape routes, by the way. I even gave you escape routes. However, it's worth noting that many African countries criminalize homosexuality, and that's no doubt. So that's something I want to appreciate in terms of. So Parliament, when passing this, according to Speaker, she said, we have entered the books of what? History. And we clearly brought out that homosexuality is a moral question, and the future of our children are being protected in terms of that. Wait a minute. Let's argue morality versus privacy. Not so. Look, ironically, even the U.S. conservative Christian groups such as the leaders of U.S. conservative Christian group family, which was Watch International, traveled to Uganda recently during and encouraged the passing of the bill. And nonetheless, so we are saying there are those who believe in it and there are those who don't believe in it. But we're going to argue the aspects of morality versus privacy, and even the argument of nurture versus nature, which is another interesting discussion. Not so. Okay, so as I said, criminalization of consensual sexual activity is one of the lacunas there. Extraterritorial application of the law is going to be another challenge there. And then the aspect to do with harsh penalties is also another lacuna there. Criminalization of advocacy is a super lacuna there. And then the issue with discrimination is a super lacuna also there. And those are, I'm now mentioning general challenges of the bill as we speak today. And then, so the bill becomes therefore problematic in some aspects when it comes to international interpretations of those aspects, because you will not divorce Uganda from other entities, you know, because we are now, look at the so-called East African relationship that we are having now. When Kenya has pronounced itself that there's a problem, and they have actually agreed with those rights, and they have agreed with the general and purposive interpretation of the word sex. And yet, most laws in Kenya are in pari materia with ours. So where you see the problem? You're going to have a problem generally. So as I said, definitive purposes have to be revisited and also given broader and purposive interpretation in terms of that. Okay, in terms of other things, other laws that are going to find themselves, with the Ugandan conflict, Universal Declaration of Human Rights, you look at that. Look at the International Covenant of Civil and Political Rights. Then another law, you want to look at what they call the Yoga Charter principles, which set principles of application of international human rights in relation to sexual orientation and gender identity, that affirm that all human beings are entitled to enjoy all human rights without discrimination, and states that measures to combat discrimination based on sexual orientation and gender identity. Then another is the European Court of Human Rights. Look at that as well, that criminalization of consensual same-sex activities violates the right to respect for privacy. Then the Inter-American Commission of Human Rights. Then the Universal Declaration of Human Rights, Article 2, by the way, which says that everyone is entitled to the rights and freedom set forth in the Declaration without distinction of any kind, or any race, color, or even sex, or language, or religion, or whatever. Look at the International Covenant on Civil and Political Rights, Article 2, which prohibits prohibition of basis on sexual orientation. Look at African Charter on People's Rights, Article 2, prohibits discrimination on the basis of sexual orientation, among others. And Article 3 guarantees the right of equality before the law, before protection of the law without discrimination. The Yoga Charter principles, principle number 2, affirms that each person, in terms of self-definition of sexual orientation, gender identity. Trouble, my friends. Look at the National Coalition of Gay and Lesbian Equality versus Minister of South Africa, which held that discrimination based on sexual violates the South African Constitution in terms of provision. Even the most recent case of Kenya that had Eric Githari, right, versus the NGO board, has also proposed that. Article 2 of the Universal Declaration of Human Rights, again, have also proposed that. Article 17 of the International Covenant on Civil and Political Rights also has talked about that. I will not go through the Yokata principles again, and then the case of National Gay versus Minister of Justice in South Africa. I've already said that, and then the Court of Human Rights also had a number of cases in terms of that. And then the Inter-American Rights Court as well also makes proposition to that. Now, what is the escape route for Uganda? Now, in spite of the fact that Uganda has challenges, we have escape routes. As I told you, we have got rather called derogable rights and non-derogable rights. Non-derogable are provided for under Article 44 of the Constitution. They include things to do with right to life, freedom of torture, or cruel, human, and degrading treatment, slavery, and savagery. Not so. And then on the other hand, derogable rights are provided for under Article 43 of the Constitution. So those include things to do with personal liberty, freedom of expression, assembly, association, and the right. So we are now propounding or defending derogable rights as provided for under Article 43. But we are aware that these have limitations. And we are now using, because the right to fair hearing, which is provided for under Article 44, is a non-derogable right, which cannot be, suspended, because it's fair, it's non-derogable for all intents and purposes. So you have to be very careful when you're arguing these. Now, although we have these non-derogables, and Article 43 will propose these non-derogables, rather derogables like homosexuality, freedom, and blah, 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 those are captured under 43. And the escape route for that would be the case of Nabagesera, okay? The Nabagesera case, which argued that in terms of Justice Musota. If you remember what Justice Musota said in terms of that. But before I go there, I would like also to assume that whatever we do should also be canvassed under Article 28, sub-Article 3A, which talks about the presumption of innocence. Every person is presumed innocent until proved guilty. Now, some of these propositions, again, that are propounded in the law, or assume, for example, in to advocates who argue on behalf of those guys that they are already guilty, How about if you say until they are proved guilty, then those advocates can be charged? But you're already charging them even before they take, their opportunity to defend. Freedom of expression, as I told you, is also another right guaranteed under Article 29, sub-Article 1 of the Constitution. However, it's not absolute, as I already told you. And derogable rights, as we argued already, those include right to liberty, privacy, right to property, and as we argued already. So non-derogable rights are those ones that have to do with life, as we said, torture, cruel, inhuman, degrading treatment, and prohibition of slavery and forced labor. And these are limited, as I already told you, in terms of the provisions of the law. So we are arguing, if you're arguing Nabagesera versus Attorney General, it involves the constitutionality of these sections, particularly the penal code and which criminalize homosexuality. And we are arguing that the court held that these provisions violated the several constitutional rights, including the right to privacy and the right to non-discrimination and the right to human dignity. Okay? And that's the only test I think that so. Now, but the case was filed at High Court before Justice Stephen Mosota, and the facts were that Jacqueline Kasha Nabagesera and a group of called Freedom and Rome Uganda organized this workshop with the purpose of training the LGBTQIA activists. And the Minister of Ethics and Integrity intervened and ordered the closure of the workshop. He alleged that the workshop was illegal, gathering homosexuals, prohibited under Section 145 of the Penal Code, not so. And in respect to that, there were issues that were raised, whether the organization of attending the workshop at Imperial Resort Beach were engaging in illegal and unlawful activities, whether the applicants' constitutional rights were unlawfully infringed, when they closed the workshop. And in consideration with another case of Onyango versus Attorney General, it was cited in terms of reliance on the applicants to highlight that even if the minister's assertion that the applicants were actually gathered to promote homosexuality was actually correct, such a promotion would actually not be justifiable because it infringed on the right of freely to express one's opinion, and that person's expression is not excluded from the constitutional protection simply because it's through others to be erroneous or even controversial or even unpleasant. So the court, what the court did here was the court observed that the protection of unpleasant or controversial or even false or wrong speech does not extend to protecting the expression that promotes illegal acts, which in itself is prohibited. In fact, it amounts to the offense of incitement or even conspiracy. So regarding the right to political participation, the Land Council for the applicants relied on Article 38 of Article 2, which guarantees a person's right to participate in peaceful activities, and court, however, found that such a right necessitates a conduct in accordance to law. And the exercise of this right basically is contrary to the law, and then it becomes prejudicial to the public interest, which again will remind me of what we're going to talk about later, where to do with public morality versus what? Private morality. Well, so key issues in terms of Nabagesera, Justice Musota delivered his opinion, and he acknowledged that Article 43 allows certain constraints to be placed on human rights, such as freedom of expression and speech, among others. And then Article 44 as the right for fair trial in life, therefore the exercise of such rights are derogable and can therefore be what? Be limited. So furthermore, Justice Musota argued that these restrictions can be made as long as they do not amount to political persecution and they are justifiable and acceptable in a free and democratic society. So that's a good escape route. Look at Article 21 sub Article 1. The Constitution provides that all persons are equal before the law, and in terms of political, economic, social, and blah, blah, blah. Okay, I'm not going to go into the details of that because that will be giving too much in the legal perspective. But what we are knowing here, what we are understanding here is that it established that promotion of morals is widely recognized as a legitimate aspect of public interest, which can actually justify restrictions. So Justice Musota determined that Uganda's law prohibit their acts. For these reasons, he determined that the organization of workshop was not a valid exercise of their rights and thus constituted an act that was contrary to what? Public interest. Remember that? So public interest versus private comes into question here again in terms of debate. Then, of course, his lordship added Article 9, which I've been arguing, of the African Charter on human rights and people's rights, that says that expression has to be exercised within the law, which has, to be domestic. So according to Justice Musota, the applicants had not exercised the right within the law because they had promoted homosexual acts prohibited by virtue of Section 145 of the Uganda Penal Code. Also, Justice Musota considered that the protection of unpleasant, controversial, false, even wrong speech is not extended to protecting the expression that promotes prohibited and illegal acts. Therefore, he concluded that the closing of the workshop had not violated the applicant's right to freedom of what? Expression. So the court also pointed the doctrine of precedent simply used to establish the European courts and other courts' position in allowing homosexuality cannot be binding on Uganda as their decisions are only what? Persuasive. And that's the argument that was proponed by many members of parliament when they are saying we cannot rely on these others because they are persuasive. But as I said, very shortly we'll go into the Eric Gitari case, which also argued the same things in terms of that. So other cases in terms of Article 27 of the African Charter, which puts limitations for justifiable reasons. Look at Chigundu and others versus Attorney General. Look at Mwanga Chivumbi versus Attorney General. Then Center for Health, Human Rights and Development versus Attorney General. Those are cases also that discuss that as well. Look at Onyango, Obo versus Attorney General, and you would appreciate some of those companies that have to do with that. Now, when you look at the definition of sex in terms of Black's Law Dictionary, 9th edition, it's defined as a sum of peculiarities of structure and function that distinguish a male from a female organism. And when you look at Britannica Online Encyclopedia, it defines sex as a sum of features which members of species can be divided into groups, male, female, complement each other in terms of reproductivity. So I'm just appealing to logic and common sense now in terms of what I would understand a reasonable man's interpretation of the word sex, rather than adapting sexual definitions that may have connotations as such. I'm just defining sex on a simple narrative. Now, if you understand nature versus nurture, when you're understanding the etiology of homosexuality is inclined on how one understands the proposition of nature versus nurture. With nature arguing with respect of what they call psychogenics of homosexuality, and nurture, on the other hand, siding in terms of environmental influences that would actually, lead to homosexuality. In other words, the bringing up of a person can actually affect their inclination towards whatever you want to call it, as propounded under that. So nurture versus nurture is a question of debate, but those of, for example, studies that have been carried out believe that homosexuality is not genetic, and therefore it is an aspect of nurture as opposed to nature. And that's something that is evidently propounded even by the various scientists who one time made a report to the president in terms of what they discovered about that particular aspect. So I will not go so much into that debate because, again, that shouldn't waste a lot of our precious time. Now, the aspect of public morality versus private morality debate. During what they call the Wolfden report, Lord Delven and Professor H.L. Hart argued in respect of public morality against private morality that was propounded by John Stuart Mill, to the effect that allowing private morality would actually disintegrate society, as allowing different consensual sexual orientations such as homosexuality, lesbianism, or even bestiality, among others, that would create a different sex in society. So in terms of constitutionality, it infringed, and therefore it would encourage unjustifiable acts or omissions in terms of that. And that was a debate that had to do with morality versus privacy. So I will not go into that again, but I'll just point out, for purposes of emphasis, conventions that would argue that way and support the opposite action of homosexuality. The European Convention on Human Rights, I already saw that. Look at Article 8, I already said that. Universal Declaration of Human Rights, Article 2, I already said that. And then and also Article 19, I already said that. And then you also want to look at international conventions on civil and political rights. And then you also want to look at other issues to do with Article 2, Paragraph 1 of the International Covenant of Civil and Political Rights. And then you may also want to look at other cases that had to do, for example, with the Supreme case of NGO Coordination Board versus Eric Gitari, which stated that the burden of justifying a limitation upon a right guaranteed under ICCPR lies with the state. And that's the case that I was telling you about, because now if the state has the mandate to do that, then the challenge is bigger. And I'll not be surprised if we see a constitutional petition in terms of this particular bill that assumably may be signed into an act. But again, look at African Charter on Human Rights, People's Rights, where the Supreme Court, in terms of the NGO Coordination Board versus Eric Gitari, cited Article 2, which provides that every person shall be entitled to the enjoyment of rights and freedoms recognized and guaranteed in the Charter without distinction of any kind of race, ethnic group, color, language, sex, religion, political, or any other national language, as it were. So it was accordingly held that LGBT rights, just like any other, was entitled to rights and protection, as again I've pointed out to you. So again, that's another challenge that we're going to have. Even the Ontario Human Rights Commission argues the same. The United Kingdom Equality Act argues the same. Convention Against Torture and Other Cruel, Human, Degrading Treatment, Punishment, what they call CAT, also argues the same. Even African Charter on Human Rights and People's Rights argues the same. The Ontario Human Rights Commission argues the same. As I said, all those components have to do with what we do. Even the Convention on Elimination of All Forms of Discrimination Against Women argues the same. Yokatata principles argue the same. And those are issues that having, which are really, which you need to take with a pinch of salt. And they are causing a lot of bad legal order, if you like, in terms of what to do. But as I said, our escape route is Nabagesera and also the African Charter, 9 Sabbatical 2, and also the emphasis of African norms and traditions. And Ubuntu Bulam and the Law, by the way, go read my book, Ubuntu Bulam and the Law, because there makes specific provisions in terms of that, where we have to argue that this other law that was incepted upon us, grafted upon us, becomes bad to the extent that we now call it's null and void to the extent of our inconsistency. So the inconsistency is in terms of African tradition and norms now. So when you look at that Kenya case, look at it fairly, because it is perhaps the litmus test of what is going to happen tomorrow in terms of, I'll not go through, there's an article that I'm going to send online, so you may want to read it, which talks about let's debate homosexuality in Uganda. And that would, if those of you who probably want to get a little bit more insight, and also look at the book Strength Mythology, Homosexuality Demystified, also, which I wrote, brings more discussions in terms of that percentage of 64% of people are normal. That we have 64% of possibility of certain species that may have tendencies of homosexuality. Apes, for example, have that tendency of, baboons on the other hand, and then pigeons on the other hand. But their sexual orientation in terms of same-sex is not really because they are attracted physically to their, the opposite sex, rather the same sex, but because of distress and because of anxiety. That's why, and in most cases, the mountings they do are not penetrative. They just do that. Some of you have seen dogs that run on people's feet and pretend like they're having, sexual encounters. Even a female dog on a hit would run on a male dog and begin mounting it. That is different from the kind of things that we're talking about. And so we can't argue that in terms of a relationship between animals and other animals and as opposed to human beings, as it were. So those are aspects that I think are important to argue as well. So please comprehend that. In terms of authority, as I said, look at Jacqueline case, which is the locus classicus in terms of trying to make a case for Uganda, by the way. Justice Mosota's decision will give you a basis under which, and of course, considerations of Onyango versus Attorney General also will also bring in that component. Now, I'll go to another interesting aspect that perhaps many of you would begin debating, when you're beginning arguments of homosexuality. Everyone would begin by, what does the Bible say? What does the Quran say? I choose to argue that the last because, as I said, it's much better we begin by appealing to people who say, first put the Bible there, first put the Quran there, and then let's see what you have. Now, if you're arguing in terms of Bible and in terms of the Quran, then we could also argue that we have quite a number of precedents, if you like, that argue that. I would argue, first of all, from the Bible's perspective, you look at Sodom and Gomorrah, which were, these are legendary biblical cities, not so, destroyed by God for their wickedness. Look at Genesis chapter 19, verse 1. And the etymology of the name Sodom and Gomorrah is uncertain, and most scholars disagree with them, but it's known in Hebrew as Sedom and Amorah, okay? And that's something you must understand. And the Hebrew was also absorbed sometime after they transcribed the Bible in different languages, as it were. But it gained an understanding that these are two cities that had been destroyed with fire, not so, and from heaven, if you like. So Sodom and Gomorrah is a substanding place where they argue that homosexuals had actually thrived for some time, and that sin had become big or irritable before God. And God gives advance notice to Abraham and says Sodom had a reputation for wickedness. And Abraham asked God, will you sweep away the righteous with the wicked? You look at Genesis 18:23. Starting with 50 people, Abraham negotiates with God and spares 10, if could be found. God sends 2 angels to destroy Sodom and Gomorrah. Lot welcomes particular individuals into his home, the angels, of course, but all men in town surround the house and demand that he surrenders the visitors so that they may know them. And the word knowing them biblically means a sexual intercourse. So Lot offers his virgin girls. Said, no, please don't do that. I'd rather give you my virgin girls. But they refuse. They say, we want the other guys. So you can imagine, it's the same thing, a little bit of what's happening now. And the angels tell Lot, by the way, just don't worry. Just go away, run, we're gonna, rain hell on these guys. They're joking. So Sodom and Gomorrah is something that is important. Then when you look at Deuteronomy also, again, Deuteronomy 29, 21 to 23 refers to the destruction of Sodom and Gomorrah. It's also, please look at that. When you look at Deuteronomy, look at Jeremiah also. Jeremiah 23, 14, 49 to 17 and 18, 50 to 39. Lamentations also 4, 6. Also, they talk about Sodom and Gomorrah. Ezekiel compares Jerusalem to Sodom when Jerusalem was sinning against God. Amos 4, 1 to 11 talks about the Israelites that hated them like Sodom and Gomorrah, and they did not repent. Zephaniah 2, 9 talks about Moab and Ammon, and they will end up like Sodom and Gomorrah. Think about that. Jeremiah 19, 1, 11 makes a case for that. So the Bible, without any apology, makes a lot of inference in terms of that. Leviticus 18:22, do not practice homosexuality. Having sex with another man, with another man as with a woman is detestable, is a sin. That's what Leviticus 18:22 says. Leviticus 20:13, if a man practices homosexuality, having sex with another man or with a woman, both men having committed a detestable act, both are put to death. Imagine, that's how serious it is. So maybe I would understand why Ugandan parliamentarians may have very stringent penalties in terms of that, maybe of biblical invocations. So please look at those. They also give you even 1 Kings 15 verse 12. Okay, it says, put away a male cult prostitute out of the land, and then Romans 1:18 as well. God shows his anger against sinful, wicked people who suppress the truth by their wickedness. Okay, so all those are invocations from the Bible. 1 Corinthians 6, 9, 11, again, and then 1 Timothy 1:8 is also another which also talks about that. Romans 1, even today the term nature in terms of Phyllis and disgrace, a theme here described by Paul, in no uncertain terms describes what is happening today. Then when you go to the Quran and the Hadith and scholars who debate on homosexuality, the Quran itself argues that if two men are guilty of lewdness, so punish them. If they repent, amend, leave them alone. So they give the option of helping them. Look at Quran, Surah 4, okay, 16, where it talks about tafriz, and then where he said to his people, ye do not commit lewdness in terms of such actions before you, okay, in terms of lust on another man in preference of a woman. Look at Quran, the Quran 7:8, Surah 7:8 to 83. All is just another invocation where they said, be careful of such actions. When you look at the Quran 26, Surah 26, 165 to 173, also he brings in the aspect of loot. And I think the inference comes from the loot of the city in terms of that, of Sodom and Gomorrah. Then the Quran 27, 54 to 58, he said, behold, he said to his people, you do not commit lewdness such as the people in creation ever committed before you. You do not approach men and cut them off in their way if they practice such wickedness in your counsels. Incredible applications here. Quran 29, Surah 29, then 8 to 31 also. Then the Hadith, as I said, the writings of God-fearing men and the prophets alike. Salih Buhakari narrates that, and he brings it and he says the prophet turned out on such and even hated such acts. When you look at his writings, Salih Bukhari 772. When you look at Sahih Bukhari also 88, 82. And then Abu Duwad, and then Sunnah Abu Duwad as well. And then when you look at other people, look at Saud Buhari, as I told you, makes that proposition, and then Sunnah Abu Duwadi again makes that proposition in terms of the different invocations. So we are very clear from the word God that invocations, both in Holy Scripture and in common sense, as it were, appeals to your inner senses that acts that are against the order of nature, perhaps things that are unacceptable, and this ideology of saying that it is genetic of me to like my, fellow sex individual is not supported by evidence or by science. It's more like nature and therefore inflicted. So there you go, even as you begin to argue and demystifying the component of homosexuality in Uganda. As I said, my friends, please pay special attention to my book, Strict Mythology Demystified, and look for this article says, let's debate homosexuality in Uganda. Please look at that. It will give you more emphasis in terms of what is required. Okay? God bless you, and have a nice time as you deliberate and wait for His Excellency, whether we'll have the mandate and the courtesy and the vigor and the charisma to sign this bill into action. I dare him, Mr. President, if you are Sabalwanyi, like you claim to say, put your finger on it, and we'll see. There you are.